In a move that has sent shockwaves through the tech and publishing industries, AI powerhouse Anthropic has agreed to a staggering $1.5 billion settlement in a copyright infringement lawsuit brought by a group of authors. But here's where it gets controversial. While this settlement is being hailed as a landmark victory for creators, it also raises critical questions about the future of AI development and the boundaries of fair use. Could this be the beginning of a new era of accountability for AI companies, or does it stifle innovation? Let's dive in. The lawsuit, filed in a California federal court last year, accused Anthropic of using pirated copies of approximately 500,000 books to train its large language models. According to Justin Nelson, the author's attorney, this settlement, if approved, will mark the largest publicly reported copyright recovery in history. To put it in perspective, each work involved in the case would yield a gross recovery of $3,000. Nelson described the outcome as nothing short of remarkable, but the road to this settlement has been anything but straightforward. At the heart of the case was the claim that Anthropic had commercially exploited copyrighted works by downloading them from pirating websites like Library Genesis and Pirate Library Mirror. Anthropic, however, argued that its actions fell under the doctrine of fair use under U.S. copyright law. In June, Judge William Alsup ruled in favor of Anthropic, stating that the AI training process was exceedingly transformative and thus protected. And this is the part most people miss. While the judge upheld fair use for AI training, he explicitly stated that downloading pirated copies of books does not qualify as fair use. This nuanced ruling has left both sides claiming partial victory. Aparna Sridhar, Anthropic's Deputy General Counsel, emphasized the company's commitment to developing safe AI systems that benefit society. Today's settlement resolves the plaintiff's remaining claims, she said, and we remain focused on advancing scientific discovery and solving complex problems. Yet, the settlement's implications extend far beyond Anthropic. It could set a precedent for other high-profile cases, such as the lawsuit filed by nearly 20 best-selling authors, including John Grisham, George R.R. Martin, and Jodi Picoult, against OpenAI for allegedly using their works to train ChatGPT. The settlement structure is equally noteworthy. Anthropic will make 4 payments into the settlement fund, starting with a $300 million payout within 5 business days of court approval. Nelson's memo to Judge Alsup clarified that the $1.5 billion figure is the minimum size of the settlement. If the number of works exceeds 500,000, Anthropic will pay an additional $3,000 per work. This sliding scale ensures that authors are compensated fairly, but it also underscores the sheer scale of the alleged infringement. The original plaintiffs, journalists and novelists Andrea Bartz, Charles Graeber and Kirk Wallace Johnson, have yet to comment on the settlement. Their silence, however, speaks volumes about the complexity of this issue. On one hand, the settlement represents a significant win for creators who feel their work has been exploited. On the other hand, it raises questions about how AI companies can ethically train their models without infringing on copyrights. Here's a thought-provoking question for you. Should AI companies be required to license content for training, or does the transformative nature of AI justify broader fair use protections? Let us know your thoughts in the comments. As this settlement moves forward, its impact will likely ripple across industries. For AI developers, it's a wake-up call to reevaluate their data sourcing practices. For authors and publishers, it's a reminder that their rights are worth fighting for. And for the rest of us, it's a fascinating glimpse into the intersection of technology, creativity, and the law. One thing is certain. The debate over AI and copyright is far from over.